Welcome to Law Enforcement Data on Juveniles presented by the Data Practices Office. We are a statewide resource on data practices and the open meeting law. We field informal inquiries about both of those laws and assist the Commissioner of Administration with their responsibilities. We have a wealth of information on our website and a listserv that you can join to learn more. This program assumes that you're familiar with general law enforcement data and Section 13.82. If you need a refresher, you might be interested in our all-day adult law enforcement workshop or our YouTube series on law enforcement data. We'll link to that in the description. These slides will be available on the Data Practices Office website, and the link will also be in the description. Our objectives with this training are to gain a better understanding of the laws governing juvenile data. This includes juvenile bad actors or juvenile delinquents, juveniles who are witnesses and victims, access by parents and guardians, and other provisions related to juveniles and law enforcement. We'll also apply the law to practical scenarios. As a reminder, there is a public presumption for government data. This means we start from the perspective that the data are public, even for law enforcement data and data about kids. An entity is prohibited from withholding or redacting data unless there is a state or federal law that requires or allows it. Let's review the classifications of data. Since this training focuses on peace officer records of children, this chart only includes classifications of data on individuals. Public means that anyone can have it for any reason. An example is Section 13.82 Subdivision 2J, which says that age and sex of a juvenile delinquent taken into custody are public. Private data means that the public can't have access to it, but the data subject, those within the government entity who need it to do their work, entities with statutory authority, and those with written informed consent to the data subject can have access. An example of private data is the name of a juvenile delinquent. The public cannot have access to that under Section 260B.171, Subdivision 5, which we'll talk more about. Confidential data is the most restrictive classification, and neither the public nor the data subject can have access. An example would be active investigative data about a juvenile treated as an adult, and we'll talk more about when that happens. In general, a court order can also grant access to not public data. This slide is a reminder of how Section 13.82 works for adults and juveniles treated like adults. When there are active criminal investigative data, there are some data that are public all the time, some data that are private all the time, and some data that are confidential, protected, non-public, active investigative data. If the call or incident did not result in a criminal investigation, then the data are presumptively public because there's not a statute that classifies the data. If they're inactive criminal investigative data, most of the data become public under Section 13.82, Subdivision 7, except for a few data elements noted here. As we'll discuss, data on juveniles in a delinquency proceeding have different classifications and outcomes. A lot of the data that we'll talk about today is private. Who can have access to private data? As we saw in the classification chart, access to private data is limited to data subjects, those with statutory authority, and those with informed consent or court order. You'll see on this list a combination of all of these avenues to access. A minor child can have access to their data. The Data Practices Act does not define minor or say when a minor can consent to releasing private data. Chapter 645 of the Minnesota Statutes provides the general definitions that apply to statutes and simply notes that a minor is someone under 18 years of age. A parent or guardian may stand in the place of a minor child, so they can exercise the access rights on behalf of their child. We presume that parents have access rights unless the law enforcement agency has reason to know that the parent's rights have been limited through a legal instrument. Law enforcement agencies do not need to search for a document or otherwise investigate. The law presumes parents have access unless you know otherwise. Kids' attorneys can also have access, but law enforcement agencies need to have proof of representation and ideally signed informed consent for access to private data. Guardians ad litem will get access via court order. Law enforcement agencies will want to review the court order to see what it covers in order to provide access to appropriate data. One provision of the Data Practices Act says that minors may ask entities to withhold their private data from their parents or guardians. As I noted, there is not an age limit or requirement for a minor to make this request. Law enforcement agency will have to decide. This slide lists some considerations as law enforcement agencies make this determination. The request must be in writing. Also, law enforcement agencies should have a policy to explain to minors how they can use this right. Sometimes this is listed in law enforcement agencies' access policies, so be familiar with your entity's process. Or it can be part of the conversation that law enforcement agencies have with minors they interact with. However your law enforcement agency does this, there should be documentation of the policy that your agency has. We're going to turn to data about juvenile delinquents and other juvenile bad actors. In general, data about juvenile delinquents are classified under 260B.171 subdivision 5. We'll talk specifically about traffic offenders later in this presentation. I'm using the phrase juvenile delinquent here to mean a minor who is or may have been delinquent or is or may be engaged in criminal acts that would result in a closed juvenile proceeding. There's a strong public policy that most things that kids get up to when they're kids should not follow them and negatively impact them for the rest of their lives. Therefore, some kids that commit certain offenses have a higher degree of protection than adults. On the flip side, some kids commit certain offenses that are so serious we treat them as adults and they receive full adult-level due process in an open proceeding. Under Section 260B.171, Subdivision 5, peace officer records of children are private data on juveniles who are or may be delinquent or are or may be involved in criminal acts, except when the proceeding is public. There are no confidential data on juvenile delinquents where the proceeding is closed. However, law enforcement agencies may withhold private data from the child or their parents or guardians if disclosure interferes with an ongoing investigation. Whether a law enforcement agency treats a juvenile's data like adult data depends on when a proceeding is open to the public. If there was not a public proceeding, meaning that either a juvenile was not arrested, charged, or cited, or the age and offense dictated a closed juvenile proceeding, then the data are classified by 260B.171. The general approach to determine when there is a public proceeding is to look at the age of the juvenile and the offense that they are charged with. If you aren't sure, this is a good time to connect with the county attorney's office. Sometimes juveniles come in on one charge, but it gets changed later. So if there are questions about where a juvenile is in the process, definitely reach out to the prosecutors. Data about an offense and an offender where the proceeding is open to the public are classified under Section 13.82 rather than 260B.171. We'll talk on the next slide about when juveniles have open proceedings, but note that a juvenile who is 13 and under, no matter what the offense, would have a closed hearing and their data are classified by 260B.171. Law enforcement agencies will treat juvenile offender data like adult offender data when there has been a public proceeding, which is dictated by the age of the juvenile plus the offense. This makes sense because they will appear in a public proceeding where any member of the public could attend. Juvenile offender data are treated just like adult offender data when the juvenile is 16 or older and has committed a felony-level offense. This also includes juveniles in the EJJ process where certain parts of their hearing are open to the public and where the adult sentence is imposed. For juveniles who are 14 or 15 and certified to stand trial as adults and they have committed a felony, then their data are treated like adult data. As noted on the previous slide, data on juveniles who are 13 and under, no matter the offense, are classified by 260B.171 and their identities are private. When the proceeding is closed based on the juvenile's age plus the offense, and the data are classified as private by Section 260B.171, the data subject, the law enforcement agency, those with informed consent, and those with statutory authority may have access. Sharing with the individuals on this slide is required by statute. Pursuant to a juvenile court order, to a parent or guardian, unless it will interfere with an ongoing investigation, to schools, which we'll talk about in a moment, and then to the public. The public has a very limited right of access to certain data about juvenile delinquents who are arrested, cited, incarcerated, or otherwise deprived of liberty, where the proceeding will be closed. In those cases, the public may have access to the age and sex of the juvenile, but not the name or address. This is different from an adult, where the name and last known address of an adult arrestee are always public. When a law enforcement agency receives a request for data about an incident that involves a juvenile for whom the proceeding would be in closed juvenile court, a public data requester can receive the incident report, but the identifying information of the juvenile will need to be redacted. That way, the public can still access the information about the agency's response to an incident while protecting the identity of the juvenile. Releasing private data to a victim is also required in certain circumstances. A victim may write to the prosecutor and ask for access to private data on juvenile offenders. The prosecutor must determine if releasing data would interfere with the investigation or if the request is motivated by a desire to engage in unlawful activities. If so, the prosecutor must withhold the data. However, if release to the victim would not interfere and was not motivated by retaliation or similar by the victim, then the prosecutor must release. If a law enforcement agency receives requests from victims for private data on offenders, they should know that the data are private and refer those requesters to the appropriate prosecutor. Also, prosecutors and law enforcement are required to share with crime victims reparations boards in certain circumstances, according to section 611A.56, subdivision 2. Last two slides listed the required sharings, and these are the permissible sharings. So some private data may be shared, and it's in the discretion of the law enforcement agency to decide whether to disclose. One is to other law enforcement agencies when the exchange of information is pertinent and necessary for law enforcement purposes. There's a similar provision in 260B.171, subdivision 5, to the provision in 13.82 that facilitates sharing between law enforcement agencies. A law enforcement agency may request data classified as private juvenile delinquency data. The agency holding the records determines whether it is pertinent or necessary. You may also release to juvenile diversion programs and to local social services agencies to promote the best interests of the child. We're now going to turn to juvenile traffic offenders. The same general approach applies, which means law enforcement agencies need to look at the age and the offense to determine whether the driver will be treated as an adult or a juvenile. Juvenile traffic offenders are not considered delinquent, so their records are treated according to a different provision under 260B.225. That section notes that there are two types of juvenile traffic offenses. Again, the analysis is similarly based on whether the court proceeding is open in adult court or closed in juvenile court. In determining which court has jurisdiction, we still look at age and offense. So releasing identifying data about juvenile traffic offenders depends on whether it is an adult court traffic offense or a major traffic offense. The offenses on this slide are adult court traffic offenses, and it's exactly how they sound. These drivers will go to adult court, and anyone can go and see them and hear the proceedings. Therefore, there isn't that need to protect the juveniles' identities in these circumstances. We treat them like adults for these offenses, and they are consequently called adult court traffic offenses. If they're 16 or 17-year-old drivers, and the offense is a petty misdemeanor traffic violation, a DWI violation, or a misdemeanor or gross misdemeanor that is part of a DWI violation, we're going to treat these juveniles like adults, and their data are classified under section 13.82. That means the public can have access to the name and identifying information of these traffic offenders. Major traffic offenses are 16 and 17-year-old drivers plus any offense that is not an adult court traffic offense, and any drivers 15 and under plus any offense. For adult court traffic offenses listed on the previous slide, drivers are treated as adults for data practices purposes. For major traffic offenses, the public policy scales tip towards privacy and the identities are private. So you need to pay close attention to the age of the driver and the offense for which they are being investigated or with which they are charged or cited. If a juvenile driver is cited for a major traffic offense, their age and sex are public per sections 260B.171 subdivision 5 and 13.82 subdivision 2. Turning to state accident reports. Your agency may need to file the state accident or crash report in certain circumstances. These reports are generally not public, but certain parties can get access. Reports are confidential, but DPS and law enforcement agencies shall release upon written request by parties involved, those suffering injury to person or property, representatives of the estate or surviving spouse, or legal counsel and insurers for the above. For juveniles, remember that their identities are private if it was a major traffic offense, so you would need to redact identifying information on those individuals. For 16 and 17-year-olds involved in an adult court traffic offense, you treat them like an adult and their identifying information can be provided to the parties allowed access. So you use the same analysis for state accident reports as incident reports. I want to turn now to data on juveniles that law enforcement may create or maintain that are not about juvenile delinquents or other bad actor juveniles. If an agency has data about a juvenile victim or witness, their data are classified by Section 13.82, subdivisions 8, 9, and 17, and are classified accordingly. We'll talk about subdivisions 8 and 9 on the next slide. Some of the provisions in 1382, subdivision 17, require law enforcement agencies to make a determination before data are classified as private. For juvenile witnesses, law enforcement must determine whether the subject matter of the investigation warrants protection. For juvenile victims, classification depends on the offense. Juvenile victims of criminal sexual conduct or sex trafficking receive automatic protection and no additional determination is needed. For other offenses, the victim must ask and law enforcement must determine that there is a safety concern. Law enforcement agencies must establish procedures for making and documenting these determinations. If a juvenile is an alleged delinquent and a victim or witness, then the juvenile gets the protection of Section 260B.171 and their identity is private. Data in child maltreatment investigations by law enforcement have differing classifications depending on what happens in the investigation. These data are classified by Section 1382, subdivisions 8 and 9. Active or inactive data that identify a victim of child abuse are private. Data that identify a reporter of abuse under Chapter 260E are confidential. Data that become inactive investigative data because of the statute of limitations has run or the case is not pursued are private. Investigative data used at trial become public. So investigative data that would normally be classified as confidential or protected non-public while they are active investigative data become private if the case does not go through the court process. So if either the law enforcement agency or the prosecutor decides not to go forward, the inactive investigative data become private. If the statute of limitations runs before charges can be filed, the data become private. This is different from other types of cases where investigative data become public if the investigation is not pursued or the statute of limitations runs. But similar to other types of cases, if a child abuse investigation goes through the court process, then the data become public once they are inactive, unless the judge issues a protective order. So for juvenile victims of child maltreatment, you're always going to redact their identifying information and the identifying information of the reporter. Then, depending on what happens in the investigation, some data might become public or private. There is broad authority to share data between law enforcement and agencies conducted in civil maltreatment investigations. This is so the authorities can pool their information and coordinate their respective investigations to avoid duplication of efforts and to make sure both investigations have all the information needed. This includes sharing active investigative data with social services and other civil agencies. Those data are classified as confidential or protected non-public at the social service agency, and once the criminal investigation concludes, they become private at social services, and as discussed on the previous slide, depending on what happened in the investigation, they might be private or public at the law enforcement agency. The statute contemplates that social services and law enforcement agencies are coordinating their investigations, so law enforcement agencies should notify social services when their data becomes inactive so that social services can maintain the data appropriately. Another provision that might come up related to child maltreatment investigations are videos of child abuse victims. Section 13.821 restricts certain types of access to these videos. As discussed on the previous slide, these videos are generally classified by 13.82 as private. A data subject may not obtain a copy of these videos without a court order of a video in which a child victim or alleged victim is alleging, explaining, denying, or describing an act of physical or sexual abuse. Normally, data subjects may inspect or have copies of private data about themselves. Under Section 13.821, a data subject may not obtain a copy of the video. They may inspect, that is, view the video, but law enforcement agencies cannot provide a copy. When viewing the video, data subjects may not make their own copy using their phone or personal equipment as they could for other types of data. There are certain required sharings for law enforcement agencies and schools. Law enforcement agencies must report drug or alcohol violations to a school's pre-assessment team. Law enforcement agencies must notify a principal or superintendent if a student commits an adult crime, the victim is a student or staff, and sharing is reasonably necessary to protect the victim. Without statutory authority, law enforcement agencies must have consent or a court order or a subpoena in certain circumstances to provide access to not public data. Law enforcement can decide how much is necessary to notify schools for these purposes. For some of the offenses, if the student is the right age, their data may be treated like adult data, so a law enforcement agency might provide more access to the school because there are more public data. Where it is a situation with a younger offender, where most of the data are private, the law enforcement agency might choose to provide the minimum amount to satisfy the statutory requirement to share. One question that we receive is how body camera data of juvenile bad actors is classified. Unfortunately, this is one of those areas that is unclear. Whether the videos are classified by 260B.171 or by 13.825 will have consequences for how the data are classified and who can have access during and after the investigation. 13.825 classifies some body camera data as public and some as not public. Active investigative data are confidential or protected non-public. Section 13.82, subdivision 15 allows access to active investigative data and private body camera data for certain public benefit purposes. Body camera video that show a discharge of a firearm, use of force resulting in substantial bodily harm or fatality are public. By contrast, as discussed in this presentation, 260B.171 classifies peace officer records of children as private when the proceeding is closed. Data are private both during the investigation and after, which means data subjects get access. There's also not a public benefit exception. Law enforcement agencies will need to have a conversation with legal counsel to determine which statute classifies body camera data about juvenile delinquents at your agency. Agencies must do the risk assessment around the two interpretations and then be consistent in protecting and providing access to the data. Now let's walk through some scenarios. Scenario 1. Lake Wobegon Police Department requests an inactive criminal sexual conduct report from St. Olaf Police Department on an adult perpetrator. The report lists a juvenile who was the complainant and victim. Can St. Olaf Police Department release the report to Lake Wobegon Police Department? The answer to scenario 1 is yes. The data are inactive investigative data, so most of the data are public and anyone can have access. However, the identity of a victim of criminal sexual conduct is automatically private, even when the data are inactive investigative data. Section 13.82, subdivision 24, allows for access to not public data by a requesting law enforcement agency if it is necessary and pertinent in initiating, furthering, or completing an investigation. Same scenario, what if the request does not meet the pertinent and necessary requirement? Can St. Olaf PD share the data? The answer is yes. Remember that the data are inactive, so the report and investigative data are still public. But the criminal sexual conduct victim's ID is private, and if it is not necessary and pertinent to share that data between law enforcement agencies, then that identity would need to be redacted. Note that this is not because the victim is a juvenile in this situation. There is no general requirement to redact juveniles' data. Here it is because the victim was a victim of criminal sexual conduct and they get automatic protection. Scenario 2. A parent requests all police reports that involve her son, who is currently 17 years old. There is one responsive report from last year when he was cited along with 2 other juveniles for underage drinking. What can law enforcement provide? Officer records of underage drinking are private data under 260B.171. Private data can be accessed by the data subject, those within the entity whose work assignment requires access, or those with statutory authority or court order. Parents can have access to private data about their children. So mom can have data that relate to her son, but she cannot have data on the other individuals. Their identities are private and must be redacted. Remember that identity is more than a name. So for those other individuals, you would want to redact any identifying information in addition to their name. What about the same scenario, but now the son is 18 years old? What can mom access? What a difference a year makes. Mom cannot have access to the data because it is private data about the son who is no longer a minor. Only the son has the right to access data about himself because the data remain private. The data were classified as private at creation under 260B.171, subdivision 5, and the classification doesn't change when the juvenile becomes an adult. It's only accessible to the mother in this scenario if she has the informed consent of her son. For scenario 3, we have two circumstances. A 12-year-old is taken into custody for murder. A 17-year-old is taken into custody for felony assault. What can law enforcement release to the public? Both of these kids committed what would be a felony and both were taken into custody. Age matters here for data practices purposes. Remember that data about juveniles who are 13 and under are private pursuant to 260B.171 subdivision 5. Under Minnesota law, they are not treated like adults, so the public can get a redacted police report that includes the age and sex of the juvenile, but no other identifying information. By contrast, the 17-year-old is treated like an adult because of the felony charge, and the proceeding will be public, and their identifying information, their name and last known address, are part of the super public arrest data in section 13.82, subdivision 2. Scenario 4. A 16-year-old was arrested after allegedly committing a felony-level assault. Media requests the mugshot. Booking photos are public under Section 1382, Subdivision 26, but Section 260B.171, Subdivision 5, Paragraph C restricts the use of juvenile booking photos. Is the booking photo of the juvenile public? Because this was a 16-year-old who was arrested for a felony, they will likely have a public proceeding. Law enforcement agencies have a reasonable amount of time to respond to a public data request. Once a law enforcement agency knows that there will be a public proceeding, then the data would be public under 13.82 subdivision 26 because the juvenile will be treated like an adult. If there is any question of whether the charge will change and the proceeding will be closed, then the photo would be private under 260B.171. Again, this is a time where law enforcement agencies will want to connect with county attorney's offices to determine whether the proceeding will be open if there's any question. Scenario 5. A sheriff's deputy pulls over a 17-year-old driving erratically through a busy residential area. After determining that the driver is intoxicated, the deputy takes her into custody and she is charged with a DWI and reckless driving. The members of the public who saw the incident are curious and make a data request to the sheriff's office for the report. What can the office release? This juvenile driver is treated like an adult, and the 1382 analysis applies. This driver is 17 years old. She was charged with a DWI and a traffic misdemeanor arising out of the same behavioral incident, and she will have a public proceeding. Therefore, her identity is public, and any data that you would provide for an adult, you would provide for this juvenile. Scenario 6. Law enforcement pulls over a 15-year-old driver with an instructional permit at 1 a.m. The officer notes that the passengers in the car are all minors, and the driver is not supervised by an adult licensed driver. The driver is cited for driving without supervision. The officer notes that the passengers could have been cited for curfew but have been given a warning and parents notified. What is the classification of the identity of the driver and the passengers? Scenario 6 answer. The driver in this case is a 15-year-old, which means that the juvenile court has jurisdiction and her identity is private, and her data classified by 260B.171. We sometimes receive questions about whether data on juveniles like the passengers are really classified by 260B.171, because ultimately the officer decided not to cite them for a curfew violation, even though it was noted in the report. Because the language of 260B.171 subdivision 5 says are or may be delinquent, and the strong public policy to protect alleged juvenile bad actors, I think the intention was for the classification to apply even when it's determined that the juvenile was not ultimately delinquent. If this had occurred at 10 a.m. and the passengers were merely witnesses and not out past curfew, their identities would be classified by 13.82 as either public under subdivision 6 or private if the law enforcement agency determined that the subject of the investigation warranted protection. This type of offense might not rise to that level, but that is left to the discretion of the law enforcement agency. Scenario 7. Mom calls police to report dad for abusing their minor child. The police department notifies social services, which opens its own investigation. The police department closes their investigation and does not send it to the prosecutor for charging. Upon request, what can the police department release to dad, social services, or a local reporter? Remember that active and inactive data that identify a victim or alleged victim of child abuse are private. Investigative child abuse data that do not result in a court process are also private. Data subjects include a minor's parent, so dad can have access to data about him and his child, but mom's identity as the reporter and other information about her are private. These intrafamilial cases are difficult to untangle when you receive data subject requests. The goal is to provide the access that you must for data subjects while redacting other identities sufficiently that someone unfamiliar with the case would not know who the other data subjects are. Social services may get access to data, including active investigative data, to coordinate their own investigations, and vice versa. For a reporter, they are members of the public. That means for this type of case, without a court process, only heavily redacted superpublic data under 1382 subdivisions 2, 3, and 6 are available to the public. And if the reporter asks for the report by the name of any protected identity, the law enforcement agency should respond that there are no responsive public data because the law enforcement agency cannot confirm those protected identities. Scenario 8. A guardian ad litem contacts your agency and requests data about an active child maltreatment investigation. They name the child in the request. What can the guardian ad litem access? Scenario 8 answer. As discussed in Scenario 7, the identity of the child is private. The guardian ad litem has a court order that details their ability to perform their duties. You will want to review the order with legal counsel to determine if the guardian ad litem can have access to private data and the scope of their access. Scenario 9. Pawnee PD receives a request for all data about Burt Macklin from the U.S. Air Force. The request includes a signed consent form from Burt that meets the standards of the Data Practices Act. Your agency has a closed delinquency case from when Burt was 14, a speeding citation from when Burt was 18, and an open case of trespassing in a local park. What can you provide to the U.S. Air Force? If you have reviewed the consent form and it allows access to private data, you can provide access to data about the delinquency case about Burt. Burt's adult speeding citation is public data under 1382. Because the trespass case is currently open, the U.S. Air Force can only get the superpublic data under 1382, subdivisions 2, 3, and 6, because Burt is an adult and there are active investigative data that are confidential or non-public, which means neither the public nor the data subject can have access. Scenario 10. A reporter asks to inspect police department records about an accident involving 2 juvenile drivers. Dom was charged with driving with a suspended license, a misdemeanor, and Twinkie was charged with a DWI. Can the reporter access the data? We don't know how old Dom and Twinkie are in this scenario, so the analysis is how old and what is the offense. Whatever the age, Dom's identity is private under 260B.225 and 260B.171 because driving with a suspended license is a misdemeanor offense. 16 and 17-year-olds with non-DWI misdemeanors are major traffic offenders, not adult court traffic offenders. Similarly, anyone 15 or under would also appear in juvenile court. Twinkie, however, was charged with a DWI. If he was 16 or 17, he's going to adult court, and we treat his data like adult data, so his identity is public. If he is 15 or under, his identity is private because the juvenile court has jurisdiction. Congratulations! You made it through DPO's Juvenile Law Enforcement Data Training. These are some key takeaways and action items. Juvenile data is challenging but can be manageable. Is the proceeding public? How old is the juvenile? And what, if any, is the offense? You can locate and review your agency's policy on minors withholding data from their parents or guardians. You can volunteer to take the next data question with a juvenile offender and walk through the analysis with a colleague. As always, you can reach out to the Data Practices Office with questions. We're here to help talk through these issues with you. And you can always refresh your memory by watching portions of this training again. Thank you for taking the time to watch this video. Feel free to reach out to the Data Practices Office with any questions you may have about this training or any other data practices question. Have a great day.